Okay, it appears as though Mr. Gordon is not in a place where he has a good audio connection. Ms. Metz, can you hear me?
I'm on the same computer with my sister here. I'm Gerald Gordon.
Okay. And Ms. Jackson, can you hear me?
Yes.
Okay. All right. If I recall correctly,
Steve,
Mr.
I can hear
Adams,
you.
were there 8 children?
Yes, sir.
And 5 of them wanted to transfer the home to the individual sibling that was living in the home. 3 of
Yes,
them not.
and 3 of them.
So take me from here. I think the last hearing we had, I requested that a market analysis be done of the property to determine whether or not the remaining 3 siblings were getting the true value, their true percentage interest in the value of the home.
Yes, sir. Mr. Gordon, he brought it in this morning, and he's got a copy. Let me just let him explain it to you, and we can show it to you. He found another home like it that sold for $92,000. We put it, and Ms. Metz brought it up. We put it in the inventory and agreed it was worth $80,000. The county had it then at 74 something.
The what?
In the inventory, I'm sorry, Judge, we put it in at 80 by agreement.
Okay.
And that, but he's got a thing, show it to the judge and explain it to him, Mr. Gordon.
Yes, Your Honor, I got a market analysis on it. And this house here, that's off of Trinidad, it's sold at 92, and it's 2 years older than the house that we're talking about.
Okay. Has that been filed with the court?
No, he just brought it in this morning. I can file it with the court.
Okay. I mean, so if you're talking about 8 children and $12,000 higher price, you're talking about
$1,500.
$100 each.
Right.
Hey, Your Honor.
Yes.
This is Gerald Gordon.
What is the name of the sibling that is actually living in the house and wants to buy the house?
It's me, Gerald Gordon.
Okay, go right ahead, Mr. Gordon.
Okay, I'm Gerald Gordon, and they negotiated the $80,000 price when we got the first letter from Mr. Adams. And in the letter, I was supposed to pay them $10,000, which I'm willing to do, and take care of the insurance and the taxes, which I have been doing since I've been in here. I'm following through with my portion of the deal. I don't see why they're not following through.
Well, we never got it appraised. I tried to get it appraised. We never got it appraised. Y'all wouldn't sign it so I can get it appraised. So I had to go on my own and get appraised.
Anybody was welcome to have the home appraised at any time.
They wouldn't sign it, Your Honor. Sign what? To get it appraised. We talked about getting it appraised at fair market value. And you never would sign it. You never sign it to be appraised.
No, I can only listen to one person talk at a time. So please don't interrupt each other.
Okay. When this first started, they said they were gonna buy us out. I said, let's get an appraisal and get a fair market value. And they never could get nobody to come to agreement to get the appraisal until you said for me to go and get an appraisal and I had to pay for it. So this is the only time that the house has ever been appraised.
Okay, Ms. Metz, you wanted to say something?
Nobody ever said anything about appraisal. The only thing he gave me was to sign off on the real estate to sell the house. That's it. Everything that they have asked me to do, I have done, except sign off on the house, because we want to keep it.
Okay. Anybody else have anything to say?
Well,
I have a question.
Ms. Jackson?
I have a question. Everything is coming up about the sale of the house, but I'm concerned about the lack of disclosure, transparency, and discovery concerning any outstanding bills or debts which may be owed on the house. Once the house is sold, my concern is about the blowback from anyone that he owes when it comes time to collect that money. Who's going to pay that? I mean, this whole thing has been a battle the whole time. No one wants to be transparent and come forward. I haven't signed or agreed to anything about signing anything for a sale. So I'm not sure why we weren't allowed to conference through the lawyer or through whomever as a family to come to a complete discussion about what would be done with the home.
Okay, because you're not entitled to. Number one, you would not be liable for any taxes or insurance that were due on the home once it was sold.
I'm not concerned about the, oh, I'm sorry. Excuse me, Your Honor.
Unless you affirmatively represented that there was no such amounts owed. Number two, the will appointed co-independent executors, which was Ms. Metz and Mr. Edwin Gordon. And they were to exercise their duties independently, which means that the other children do not have the opportunity, absent fraud, to involve themselves in the gathering of the assets of the estate or the distribution of. However, I do allow the other people that are beneficiaries of the estate to question the appraisal of it. And so the court, Mr. Adams, will not be able to make a decision until you furnish that market analysis to the court.
I'll furnish it to you. I apologize. He brought it in this morning. My issue, I don't have an issue in this at all, is that I'm representing both executors and they disagree. So that's why we're basically throwing it to you. But I will give you, I'll email that to you today. And I'll give Ms. Metz one too, of course.
Okay, and Ms. Metz, if you have another market analysis, if you'll provide that to the court. If you have anything, any information as to the value of the home that Gerald wishes to purchase.
This is Gerald Gordon. They don't, but the credit union that I was trying to acquire the house through was going to do one after they got their signatures, and that's how I would be able to acquire the house. And also
an appraisal to make sure that the loan to value amount is correct.
Right. And also, since they want to go up on the price of the house, which I have no problem with, I would like to recoup some of the money that I've been spending on the house since I've been here, since it's joint tenancy. We all own it together. The three that are there, the three that are opposing.
Well, he's living in the house for free. That's a benefit.
That's the benefit.
Mm-hmm.
No, it's joint tenancy. We all own it together. The insurance and everything we all own it together.
All right, I will, I'll look at your market analysis, Mr. Adams, that Mr. Edwin Gordon has gotten. You can provide that to the court. And if you get it to me today, I'll make a decision by Wednesday.
I'll have it to you today, Your Honor.
And anything else that the other parties want to provide me today, I will be happy. But I'm going to tell all the parties while you're here right now. Your siblings, you appear to be fighting over things that are not worth fighting over. You're talking about $12,000 divided between 8 people, which comes out to $1,500 a piece, and it's not going to make a big deal for the rest of your lives. It's not going to buy you a car. It'd probably buy you a couple of 2x4s. So it seems to me to be a ridiculous fight, which I wish that you would get together and resolve. But the court will make a ruling if it is forced to. but I hope it won't be necessary. And the court will be available if there's anything else needed in the future. Just let us know. And I hope y'all's day goes well.
Hey, Your Honor. Your Honor, excuse me.
Yes, sir.
What if I'm willing to pay them the $1,500 a piece, and just to get this over with? Can we
Well,
just do that?
it certainly seems to me that should resolve the issue.
Okay, I'm willing to do it if the other side is willing.
Okay.
Are you willing?
Mr. Adams, see
He
if y'all
said-
can agreement
said-
and the court would be tickle pink with that.
But he just said he agrees to it, so that's, hopefully maybe we have it settled.
Okay, all we
Yeah,
need is
clear.
their signatures.
And the two executors could sign the deed to the property,
Yes.
so I'll do that. You agree to that, Ms. Metz, don't you?
I do.
We have it settled then, and my guy, and because and the two executors can deed it to him subject to going to 11.5 as opposed to the other four have all deeded it to Mr. Gordon anyway. They've given him their interest away, which I thought was nice, actually. So we have it settled, Your Honor.
All right. Well, I'll wait for the proper documentation from you.
I'll send you a simple order. Is that all right?
That'll be
And
fine.
Okay, sir.
Ms. Jackson, did you have something to say?
Yeah, I mean, I still have a question, or I'm still unclear about what about debts that was owed, or if there are any outside bills that are owed by them. We've never been able to find that out. Who pays for that if it comes up?
That's up to the two independent executors to take care of the bills. And it's up to creditors to file claims, and that's beyond the scope. I'm not allowed to give legal advice, but suffice it to say, I don't think that you need to worry with that. But I'll let the independent executors take care of that. And I've got to get on to another hearing. Thank you for your time. Thank you for your work to resolve it.
Fine, just as long as it don't blow back on me.
So I didn't understand none of that shit that just went on.
Okay. Is I'll get sheet.
It's 96, $12 piece for them.
I guess we gotta go to Pace.
This come and ask what the final things I can go to the credit. Because y'all gave me y'all shares, I don't have to pay that. I'm just paying them for it, which is $15 more, right?
$1,500 a piece, I think, for them three.
Yeah.
That's what it is.
Good morning, Mr. Druitt.
Good morning, Your Honor.
Okay, we've been through this before. I've heard your arguments before. I've read your authority before, so the court will grant your application. Anything else you need?
No, Your Honor, that's fine. I appreciate it.
All right, just tell me this isn't committing any kind of fraud upon a governmental entity.
Oh, no, sir. This is done quite regularly in the group of people that I deal with that handle cases for incapacitated individuals on SSI.
Sounds good.
That's why they changed the statute.
I hope you have a great one, Mr. Druitt. Let me know if you need anything else.
All right. Thank you so much. I appreciate it.
Take care.
All right, bye-bye.
Okay, estate of Maurice Richard, looks like Mr. Hines, Mr. Brinkley, Mr. Shalander, and Mr. Adams. Okay, anything like this in the future, I want it in person. This is gonna be 4 parties. Anything over 2 parties, I want it in person.
Okay.
Morning, Judge.
Good morning. I don't have you on the docket, Mr. Bradley. What are you here on?
I'm here on the hearing with Mr. Brinkley. I represent Ryan Hemingway and Hemingway Real Estate LLC, which is a party to a lawsuit that was filed that has to do with the incapacity that's been alleged for Mr. Richard. And I think Mr. Brinkley, when he argues his motion to you, it'll be a little more clear why we're here. But we're a party in interest, Judge, in support of the motion that Mr. Brinkley has filed today.
Okay, looks like we've got a motion for a scheduling order and trial setting that was filed by and we're in cause number 124514, the estate of Maurice Lee Richard, an allegedly incapacitated person. We've got a motion for a scheduling order that was filed on June 8th by Mr. Brinkley. An application for appointment of a temporary guardian of the person in the estate filed on June 15th by Mr. Brinkley. A motion for continuance of the temporary guardianship of the person in the estate filed by Mr. Adams on June 22nd. And I do not see Mr. Adams. I do see a Stafford Fields on here, and I don't know what his involvement is in this case.
I'm not sure. We're trying to figure out.
I see a photograph and someone named Stafford Fields. Are you involved in this case?
The photograph is, this is David Pace. I'm not sure how to get that photograph off of there, but I'm not involved in this case at all. I'm supposed to be in with Druitt.
Okay, we already handled Mr. Druitt's case, and that's taken care of. You can
really?
contact Druitt directly.
Oh, okay. All right.
All right, you take care.
Thank you.
What about Mr. Adams?
He's coming back.
Hmm?
He's gonna sign on right now.
Back over here where you were.
I know we can go that way, come around here.
Judge, there's one other person that's trying to get on right now, and that's my client, David Lance Richard. He's attempting to get on.
Okay, tell me what everybody's involvement is. Mr. Sherlander, what's your involvement in this case?
Yeah, and I represent an applicant for the, if there's going to be a guardian, for the guardian of the person and basically the caretaker of the proposed ward, his girlfriend of 11 years.
Okay. And David Lance Richard is the son of the allegedly incapacitated individual?
Yes, sir. And I represent David Lance Richard in both the guardianship case as an applicant in the guardianship case and as next friend of his dad in the case that we're talking about with regard to Hemingway. That's on file the 136, Judge.
Okay.
And Judge, the nature of that suit is my client Hemingway bought a piece of real estate from Mr. Richard, and the allegations have been made that Mr. Richard was incapacitated at the time of that real estate transaction, and they are asking for that transaction to be voided. And so that's why Mr. Hemingway's involvement and why we're here today as well.
Okay. Okay, we're still waiting on Mr. Adams to sign on.
I see him on, Judge. I see his, there we are.
I don't see it in here. Did you tell me, Mr. Sherlander, that Ms. Burrell had made an application also to be guardian of the estate?
No, sir, guardian of the person. Yes, sir. Some few months ago.
Okay, well, that wasn't in my paper.
She's also a defendant in the suit in 136 brought by Dean with in the case of Lance is here about.
Yeah. Okay, there's Mr. Adams. And who do you have with you, Mr. Adams?
I represent Maurice Richard,
And he is with you?
Yeah, yes, sir.
All righty. All right, you may proceed, Mr. Brinkley.
Okay, thank you, Judge. Judge, in May of 2020, Mr. Richard began to show signs of dementia. His son, David Lance Richard, had been granted power of attorney and had been taking care of his dad and helping him take care of his property. Took him to see his doctor, Dr. Indipali. And all these records we have all the records, everyone has them. The records for Dr. Indipali is the Second Advent Medical Center. And you'll see that in June, in a follow-up, Dr. Indipali made some findings, and there's actually a document that you have, Judge, where he said that this was dated June the 25th, 2020. It says the patient is examined by me today and found to have cognitive dysfunction. He is being referred to neurologist Dr. Uman for further evaluation and management. And the intent was for him to see Dr. Uman. There's a lot of things that happened that are really not germane to this hearing today, but essentially, Mr. Richard was prevented from seeing Dr. Uman by Ms. Burrell, who canceled his visits to him on two different occasions. In July of 2020, while Mr. Richard is in this condition, Mrs. Burrell took him and had the power of attorney that he had granted to his son revoked. And that, Judge, led to an onslaught of things that we're not going to talk about today, but if you go look at the APS records, you'll get a feel for what I'm talking about. But most importantly today, APS got involved and they had Dr. Julia Heiner do a psychological evaluation. And in October of 2020, she found him to be incapacitated. And you can go look at the certificate of medical exams on file. You see kind of what decision making he was able to make and what he couldn't make, which is what's relevant today. Because in November the 6th, 2020, with Barbara's assistant, Mr. Richard sold his house and his property to Mr. Hemingway. And when we found out about that, his son called and was starting to uncover a lot of different types of financial transactions. We filed a lawsuit in the 136 on behalf of Maurice Richard. We filed a lis pendens to stop any kind of transactions with regard to the real property that was sold. And we brought the suit against Hemingway and against Barbara Burrell. At this point, Judge, I'm trying to be very limited in what I'm requesting. What we're requesting is to be appointed as temporary administrator so that we can resolve the claim with the Hemingways. Mr. Hemingway, who Lance represents, they're incurring fees and expenses and losses while this litigation is pending, and it needs to get resolved. And it's in the best interest of Mr. Richard to get this resolved prior to us having a final hearing on this guardianship matter. And the reason I brought this, Judge, is you may note that we were set to have the guardianship matter resolved in June of this year. There was a continuance filed and it got continued. We then asked for another trial setting. I think we got maybe an August trial setting, and there's been more continuances filed. There's really, frankly, some more things to be done. Our concern is this thing's going to drag on who knows how long, and it's going to make it very difficult for him to resolve the case with Hemingway. And so that's what we're here today, Judge, asking you to appoint us as the temporary administrator of it's not administration, temporary guardian of Mr. Richard with the sole of, all we're asking for is the ability to resolve the claim that we have in the 136. That's the gist of what we're asking for in this motion.
All right. Then we have so you're seeking a trial setting and a temporary guardianship of the person and estate.
Yes.
And Mr. Adams is seeking a continuance.
Of
And I
this
don't have,
temporary administration, yes, Your Honor.
I'm here now, Your Honor, so we might as well go on and have the hearing.
yeah, go right ahead.
But I represent Maurice, and he buying that house back is not for his benefit. The money received for his homestead is under the control of the court, or it's been set aside.
It's under the control of what?
There's a court order where it's been, the money is tied up. I don't think it is not beneficial to Maurice for him to buy his home back. He's 81 years old. He doesn't want to move back in his home. All his furniture has been sold. I see no benefit whatsoever of buying the home back. And there's 25 acres. He's living with a lady he's been with for 10 years, and she has a much nicer home. He's very well taken care of, and he's happy there. He does not want to move back into his home.
Where does Miss Burrow live?
She lives here in Beaumont, out off Major Drive. Has about a 4-year-old home.
Frank, I'm having a hard time hearing you.
Yeah, or are you? She has a home right off Major Drive, and it's a very nice home. I've been in it. I think Josh Hines, I know, has been in it.
Well, Josh, I'm sorry, Judge, if I may respond.
Let me ask you this, Mr. Brinkley. Why, if this was filed back in December of 2020, are we just getting to this?
Well, we thought this would be, Judge, we filed the lawsuit at roughly the same time that we filed for guardianship. We figured that we would have this thing resolved by now. In fact, this thing was set for trial in June. I think June 7th was the trial setting. We wouldn't have a need for temporary guardianship had this gone to trial and we got all this resolved by then. That's why we're having to file this, because we're afraid that this thing is going to go on indefinitely, and then it's going to leave us in a bind with Hemingway as he starts to accrue more attorney's fees and expenses and interest. We need to get it resolved now. We're not going to have a final hearing anytime soon. And I think someone's asked for a jury trial on this now. So this thing could stretch out who knows how long before we can get it heard. And that's why we filed the temporary.
Judge, may I respond?
You may.
First of all, Judge, I think you hit the nail on the head. This has been going on for quite some time. It hasn't been postponed by our accounts. Things were not ready, and that's why it got postponed. We were here today before we filed this request for a temporary guardianship for actually a scheduling order and to set it for trial and give us deadlines to do everything we need to do to get it ready for trial. So I would think we'll hopefully have a trial within the next 2 or 3, 4 months. Like Frank said, all of Mr. Richard's finances are under a temporary injunction right now. I'm not sure if that's in this court or in the 136, but a court order that was agreed to by everybody, so that there's no question about his finances. He lives with this lady, his girlfriend of almost 11 years. They do everything together, Judge. The testimony is going to show they go dancing 3 nights a week, or 2 or 3 nights a week. They go out to eat 2 or 3 nights a week. They're inseparable. They go to, they walk together, they exercise together. His personal needs are more than adequately taken care of right now. There's no urgency to a temporary guardianship, and I'm not sure that I think I heard Dean say all they wanted today anyway was a guardianship of the estate, even though his motion says a person, but I didn't hear him say anything about just the estate.
No, we want guardianship. We want temporary guardianship of the person in the state so that we can resolve the Hemingway claim. And Judge, I mean, all the things.
Wait, Dean, I wouldn't finish. You just.
Oh, I'm sorry, Mel. I'm sorry. Go ahead. Sorry.
So I don't know that they even need guardianship of the person to resolve a litigation anyway. But there's just no urgency to any of this. The man's personal well-being is taken care of. He's happy where he is. I think testimony show he wants to be there. From the filings that have been made and representations by the applicant and his son, he's going to put him in a nursing home. And that's the last place in the world this man wants to go to, is a nursing home. When he's comfortable, happy with a person he has great affection for, and who takes care of him. They do fun things together. In the twilight of somebody's life, to jerk him out of activities that he enjoys, dancing, going out, meeting with people, and then suddenly putting him in a nursing home is almost cruel. Certainly would adversely affect his well-being. So, Judge, I just don't see that there's any urgency to doing anything today. If we get a scheduling order and get this thing set for trial, all we're talking about is a few months.
Let's see, Mr. Hines. Okay, you're an ad item. Do you have something to say? I saw you raise your hand.
Yeah, if I could just throw in my 2 cents. I think from what I'm reading is that he's only asking for a limited temporary guardianship to deal with this Hemingway case, Judge. And I've read the Hemingway pleadings. I don't know the facts necessarily, but if Mr. Hemingway was truly an innocent purchaser and they're trying to undo that, at the end of the day, the longer that goes, then that is just more cost to the estate because of interest and everything else, potential damages against the estate. And so I think if that's the route that's going, then I think that would be in the best interest of the estate to resolve that Hemingway case, because it would reduce the exposure to the estate as far as damages go. That's just my opinion on that.
Okay, Mr. Bradley?
Judge, that's exactly the point. I mean, the only urgency in this whole matter is with Mr. Hemingway. You know, he's maintaining real estate. He's got a loan for this real estate. He's having to maintain it every month. He's losing potential rental income off of this. And this is continuing every month at $2,000 to $3,000 a month on a piece of property that he very well may not end up with at the end of the day. When this transaction took place and Mr. Hemingway was notified that there may be some incapacity issues with Mr. Richard, he immediately said, show me the documentation of the incapacity and, you know, we'll go about our business and we'll undo the transaction. So Mr. Hemingway's not adverse in any way to the transaction being voided as long as he gets reimbursed all the expenses that he's out of that are continuing to accrue each month this goes on. So the only urgency really is with my client, Judge, at this point, to get him out of the litigation, to make him whole, and then let these other parties fight out the guardianship matters.
Okay, here's what I'm gonna do, because it appears Ms. Burrell, and this is only, I hadn't heard any testimony, but from the allegations that are contained within the various documents and the language of the estates code, it appears she has an interest adverse to the proposed ward. So based on that appearance, I'm going to grant the application for appointment of the temporary guardian of the person of the estate. I'm going to set this case for trial on August 18th and 19th, 20th if need be. And the applicant for the temporary guardianship, David Lance Richard, or Richard, however they pronounce it, is going to need to come in and do a proof and oath. The court's going to need something to set a bond.
And we sent an order in to you, so you have that, and you can fill in whatever you feel is necessary on that. Also, he's done here's a certificate, Judge. I'll file this. We just got this today. It's a certificate.
Okay.
Guardianship.
Get everything filed. Plan on a trial beginning August 18th at 9 a.m.
Your Honor, you haven't heard any testimony. Can we at least put some testimony on?
I have witnesses as the guardianship of the person, Your Honor.
Your Honor, I don't think a guardianship of the person is necessary. I mean,
I'm not. Say that again, Mr. Adams.
I have witnesses as to the guardianship of the person he's well taken care of where he is now and under the code.
Judge,
There's no imminent danger.
we're not trying to address that today.
Yeah, but you have allegations that the person with whom he's living had him cancel his power of attorney to his son after the date of, or somewhere around the time when he had a physician's examination that showed him to have some difficulties. And I've read that physician's examination. And so I'm still going to find that there appears to be an adverse interest until we hear all of the evidence for the full guardianship. So this is a temporary. I mean, I'll let you adduce some evidence if you, Mr. Adams, but
Your Honor, real quickly, I think to resolve that, Dean, do you need a guardian of the person?
No, we'll accept guardianship of the estate, which will give us the power to resolve the issue with Hemingway.
And it'll just be limited to the powers relating to the Hemingway case.
That's it. That's all we're asking to do right now.
Hold on just a second. I may have a problem with that because I want to make sure that Mr. Richard is taken care of. So, does the injunction that's entered prohibit any other changes in legal documents?
Yes, Your Honor.
And so it would be limited to taking care of his activities of daily living?
That's correct. And frankly, Judge, if we thought we could have that hearing today, we would try to address that as well. But that's going to be the hearing for August. We're just trying to take care of one thing that we can today. When we get to the final hearing, we start looking at all the records. We'll be making some arguments about what to do with the guardianship of the person. But at this point, Judge, I don't have enough evidence I'm not here today to argue that. I'm here today to try to get the Hemingway matter squared away, to get a hearing date so that we can put the evidence on and resolve the issue of whether it's in his best interest to have a different, living arrangement.
All right. Get me a revised order. And if the parties desire and can get to trial sooner, I'll try to find, if the parties are agreeable to it, I'll try to find a trial date sooner than 45 days. And I will work it all in, but the parties are going to have to be in agreement with it under the rules of court. So
we're ready to go anytime, as soon as possible. We want to go to trial. If it's the 18th of August, then we'll live with it. But if we can go sooner, the sooner the better.
Your Honor, there needs to be depositions and some records gathered. Can at least the court grant us leave to do discovery within the 30-day period of trial? Because we're only going to have
no objection.
I'll give you up until 14 days prior to the trial. And if there's anything that needs to be done after that date, ask for leave of court and I will be very liberal with you.
Okay.
If you're able to get it to trial sooner and you find you've done the discovery that you need to do and have accomplished it sooner than that, the court will be here and will entertain finding an earlier date on the schedule to get y'all to trial. But right now, I'm going to go out at least 45 days in accordance with the terms of the rules of procedure. But if the parties agree, I'll get you sooner.
Of course, Judge, you're aware there's been a jury fee paid.
Yeah, I do. I see that.
Okay.
All right. Well, y'all let us know if you need anything else.
Okay. Thank you, Judge.
So did we just do the guardian of the estate?
Yeah.
Okay.
Thank you.
Thanks.